Brittany Washington with Kane Title. So today let's talk about one of the more common title issues we run into, and that is when you are dealing with a deceased owner of a property. So stick with me here. We're going to go through some key terms that, especially if this is your first time dealing with it, you definitely need to know in order to understand what the title company is even talking to you about. These are very commonly used terms in the title industry in regards to when you have a deceased seller. So a decedent is also known as the deceased person. An estate is the property in which the decedent owned. A will is an instrument that disposes of property after the seller's death. That doesn't mean there always is a will, but if there is, that's the will. And a probate is a matter or proceeding at law relating to the estate of a decedent. We'll talk about those a little bit more in a little bit. So there's two different types of situations in which we view a decedent has passed in, and that is testate or intestate. And what that means, if a seller dies testate, that means that his or her will was probated. If they die intestate, that means that they did not leave a will. And so those have a lot to do with the things that title company needs to clear and close on a transaction. An heir is the person who, at the death of the owner of the land, is entitled to the land if the owner has died intestate, meaning leaving a will and listing the heir as the new owner. An heirship affidavit is an affidavit that contains sufficient facts concerning the life of the decedent, which can be filed for record, which helps us, if there's not a will or probate, to determine the succession of heirship. An executor is the person who is named in a will and affirmed by the probate court to administer and or sell the estate. And a power of sale is a clause that's contained within a will that grants the executor the power to sell the property from the estate. So title to a property owned by the deceased person passes to the heirs immediately upon death. However, it's important to point out that you still have to administer the estate and the necessary documentations to close on a sale and to have title insurance issued. In the state of Texas, we have two scenarios where state law will mandate how a decedent's estate passes. The applicable state law is called intestate succession. Intestate succession will apply if a will is not probated. A will has no effect until it has actually been submitted to probate. Let me repeat that. Just because a seller had a will doesn't mean it has any precedence in regards to selling a property unless it has been probated. Intestate succession occurs when the decedent passes without a will or if the will is not probated. So it's very surprising to people a lot of the time how many people pass without a will and have to go through the process of intestate succession. So when someone dies without a will or the heirs fail to probate the will, passage of the property is governed by the Texas Estate Code. So stick with me here. In many cases, intestate succession does not pass title the way most people, meaning the people who feel like they're the rightful heirs, think that it will happen. And so you can deal with some really sticky situations if you're not aware of who gets the property in the event there's no will or probate. So let's talk about the different situations in which a seller, owner of a property, can pass and how that looks in regards to the intestate succession. So there's people who pass away that are married and don't have any children. So the intestate succession, let me point out as well, for each of these different scenarios is different in regards to a homestead property for the seller and also separate property. So the charts here, you guys can take a look at it. I'm happy to provide this information too, but this is where it can get tricky because it's not a simple thing as you see. So we have people who are married with no children, or people who have children, but they have passed away after a certain date because laws change, which affects how title's transferred into whom. Or if the person who passes is single or widowed with no children, that also affects who can get the property. Or if they're single or widowed with children, will also take into account who gets the property. So as you guys can see, there's a lot of things that you need to know in regards to dealing with an estate for your title company to prepare everyone who is actually going to get the property if there's no will and it wasn't probated. Intestate succession. Again, we'll provide that information to you guys upon request. So why do you as an investor need to know this? So first of all, think about contract law issues. So to be valid, a contract must be signed by all parties that own the property. So it's not uncommon for us as title companies to find that there are more owners of the property than originally thought after we produce the title commitment and do all that research. So if those heirs, the people who are actually per intestate succession, if they didn't sign the contract, but they are required to, it can cause a lot of issues. It means your contract's not binding, and if you're dealing with a realtor, you as the investor, you have to go and get the remaining signatures on your contract in order for it to be valid. It can get really messy. So it's super important for you to be aware of who has rights to the property to make sure that you're working with the correct people. It really can have a huge effect. Another reason why you need to know this is because the process of getting to closing with intestate succession can be super complex and time consuming depending on how many decedents there are and how many people are required to sign. It can take a lot of time to document who per intestate succession is, who are your heirs. So a lot of the time you are obviously trying to close quick, right? So if you have a property and you have 12 heirs, or you think you only have 12 and you end up having 15, it can really cause some huge delays. So really important to know this stuff. So when the decedent passes, the property passes to the heirs of the decedent immediately. But again, we have to document this passage in the real property records. So if there's not a will, what we do is record an affidavit of heirship. So in order for a title company to rely on affidavits of heirship, we must be provided with sometimes we'll take two, but three separate affidavits wherein each affiant, meaning person who's signing the document, provides information about the decedent. So there's specific information that we have to get. So the disinterested affiants who sign the affidavit of heirship are people who are not related to the decedent by blood or marriage, but are aware and have known, did know the decedent for a substantial amount of time, and are also able to provide us with facts about the decedent in regards to marriage, children, parents, siblings, any potential heirs, right? So they also, one of the affiants who signs the affidavit of heirship must be able to swear to facts regarding the decedent's financial matters related to the property ownership and real estate taxes. So it's really critical that each affiant know all of the information that is required, by law in order for title companies to record an affidavit of heirship. Now, I know you've heard that term before. It's one of the most commonly used things in regards to an estate that doesn't have a will or probate is heirship affidavits. And you guys have to be super careful with this because people, just because someone knew the decedent doesn't mean that they know all the facts that we have to have in order to have a valid recordable affidavit of heirship to make sure that we're transferring title properly. This is one of the most common title issue claims that you run into post-closing. So definitely, guys, the moment you know if you're dealing with a deceased seller, call your title company and start figuring out what you need to do, especially if you've never dealt with it before, because as you can see, there are so many different situations in which the seller could be in and the estate could be in and how they need to be handled. It gets really complicated. So in order for us to rely on this, the title company also has to believe that the facts are true. So just because you have people filling this information out doesn't mean that we have to accept it. Again, call your title agent if you know you're dealing with a deceased seller. Work all this out before you get your contract executed to make sure you have everything in place. So in order to obtain the needed facts, information is sent from the title office to the seller. So this is something the title company will handle for you, getting the information they need to prepare heirship affidavits. Just make sure that you're preparing your sellers, that the title company is going to be asking some pretty intrusive questions. Sometimes people feel like we have to get kind of into what I call the nitty-gritty in these situations. Just prepare them for that because people can be taken, they get caught off guard sometimes when they're not prepared to answer all these questions about the decedent on the property. So if you guys need any additional information on that, if you want to see the slides that we had for the intestate succession, let me know. You can request it from me here.